Welcome to the Freedom California podcast. I'm your host, Samuel Coleman. This week I am joined by Matthew Hayward, Washington Outreach Director, and Lauren Bowen, Ohio Outreach Director. Join us as we discuss unconstitutional escape periods, how unions bend the law to trap public employees into paying union dues, and a victory in the ongoing Slidewaters lawsuit in Washington State. Stay tuned. All right, welcome back, everyone, to the Freedom California podcast. I am your host, Samuel Coleman, Outreach Director for the state of California. This week, we are joined by Lauren Bowen, the Ohio Outreach Director, and Matthew Hayward, the Washington State Outreach Director. Lauren, Matt, thanks for joining me.
Thank you for having us.
Yeah, thanks for having me again.
Yeah. So, Lauren, this is a question that I like to ask everyone on their first time on the podcast. It's an important question, critically important, really, to our success as a foundation. What is your favorite beverage, Coke or Pepsi?
Diet Coke.
Diet Coke.
Is my preference, and I like it with a squeeze of lemon.
That's fancy.
Yes, perhaps.
Yeah. Wow. All right. So I want to kind of get into our first issue. So, Lauren, we know that in Washington and in California and even in Oregon, we run into these issues when we're trying to help people opt out, called, either opt-out windows, escape periods, or they've signed an authorization card. Of course, this is basically a way for the union to say, well, you signed this card, you signed on the dotted line saying you would continue paying us dues for 1 year, 2 years, 3 years, and we're going to hold you to that now and make sure that you can't leave. Do you run into that issue in Ohio as well?
Oh my goodness, we certainly do. It has been an unfortunate pattern and a theme that union members encounter frequently. As a matter of fact, in the last 2 months, I've probably had 5 or 6 phone calls related to this very issue from almost all of the unions that are represented here in Ohio. So regrettably, since the Janus decision, this seems to be what unions are relying upon to keep their member rosters intact.
Right. And so, Matt, are we looking at the same thing in Washington as well with these authorization cards? Are they frequent? Are there unions that don't have these sort of opt-out requirements?
Yeah, almost all of them have that similar type opt-out windows. Some of them vary a little bit. The WEA and Teachers Union has been one of the exceptions that did not immediately adopt the opt-out windows. So other than that, every union here pretty much has adopted that opt-out window from the Janus decision forward. Many of them putting the language in months before Janus decision in anticipation of it. And then they went around and did a membership drive before the Supreme Court decision to essentially get people to sign rights away that had yet to be recognized.
Right. So when we're talking about these, escape periods or authorization cards, I think a good question to ask is how restrictive are they? Because I know we've run into situations where we've been able to help people get out of the union simply by sending a demand letter or simply by saying we will challenge this. And then other times we have to take it, all the way up the rung to court. So Lauren, how restrictive are these opt-out windows in Ohio?
They're extremely restrictive. And honestly, the language that is included in the collective bargaining agreements where these restrictions are integrated are extremely hard to decipher and understand. I mean, the language, you could sit there and read it 10 times and still not really fully comprehend when exactly the opt-out window is. And then when you finally do identify the period of time in which you're able to pursue an opt-out, it could be a period of 6 days. And then you're at the mercy of the post office to get the paperwork there, not too early and not too late.
Right. Matt, I want to pose this question to you as well. How restrictive are they in Washington?
So it varies a little. We've had some luck with sending letters, having our attorney send letters and having some of the unions allow people to get out during the opt-out window. Some of it is fact specific when people have been bullied, harassed, or manipulated into signing something without knowing what it was. and they are willing to go on the record and state exactly what happened, and have one of our attorneys follow that up, essentially saying, allow this person to opt out or we're going to file litigation against you. In those situations, they often do allow people to opt out. However, the typical case is that most unions in most situations do hold people to these windows.
Well, I know it becomes a challenge for us because, there are in California about 1.2 million unionized public employees. And if we were to try to help out every single one of them, we need a lot more lawyers. So, I think there is a push and pull of resources there for what we can do personally. And so, Matt, do you know of any litigation that the Freedom Foundation currently has to try to overturn this practice?
So yeah, we do have a case that we are considering having the Supreme Court take under consideration, Belgao. And so I don't know where we're at. I'm not an attorney, but I know that the legal team is looking at that right now and considering going to this, asking the Supreme Court to hear our case, because this is a nationwide issue. It's not a local or statewide issue.
Well, what really shocks me about these sort of opt-out windows or escape periods is that, I think when it comes to obtaining other services, we see things that are kind of similar. Like I think internet providers are notorious for trying to get you into a 2-year contract. But even then, if I went to them halfway through my contract and said, I don't want to renew in a year, they wouldn't automatically charge me again in a year. And Lauren, if I'm understanding what happened in Ohio right, when it comes to this story posted on our website with you'll have to excuse me here, I'm not entirely sure, the Ohio Public Employees or the
Yep.
OPSE?
The Ohio Association of Public School Employees.
Thank you. With this OPSE story, if I understand it correctly, this person attempted to opt out 2 days before their window and were then denied.
Yes. He has worked in a big metropolitan school district here in the state of Ohio for nearly 20 years. He's paid over $13,000 in dues over those 20 years. He has a very wonderful job, but a humble position where he was a school bus driver and now he's a truck driver. So $13,000 is a lot of money to anybody, but to him it seemed very significant. And he said to me, I have not utilized any of the services offered by OPSE in the 20 years I've been a member, and I'm getting ready to retire next year. And I'd really like to say that my last year of employment, I did not pay dues. It was a matter of principle to him. He felt it was very important. So he pursued opting out and sent his paperwork in by certified mail. And he was very careful to do it in a timely fashion so that it would get there within that very strict time window. And what happened was that he was so diligent and careful to send his paperwork in a timely fashion. It didn't get there 2 days too late. It got there 2 days too early. For the next 2 months, OPSE did honor his desire to opt out of the union. And that was wonderful news. However, he got a call saying that this November they were going to resume collection of dues because of receiving the paperwork 2 days too early. So this is obviously a situation where we really want to advocate for folks that find themselves in these really difficult conundrums with their unions, where they're just trying to do right by their constitutional rights and they're trying to honor their constitutional rights, and they simply don't want to be in the union anymore, and they're being forced because of these silly restrictions.
Well, it seems a little insane to me that 2 days too early means that you can't, like, as if they don't understand that you want to get out of the union, and if you're 2 days too early, that somehow invalidates your constitutional rights. It seems a little insane to me. But Matt, I want to push this back over to you. Are you familiar with anything like this happening in Washington?
Yeah, I was just going to mention there's another interesting point in the fine print, and many of these, as I'm sure both of you are aware, these contracts and the language are kind of bizarre in that they the expiration date is not the anniversary. Often it's not the anniversary of when they signed up for the membership card, but it's some variant time associated to that. In fact, I had a guy call yesterday and told me that he tried to opt out a month ago, and he was confused why he wasn't being allowed out because his anniversary was December 5th. And so it hasn't even come yet. And he's going, hey, I signed up December 5th, so it's not even there yet. I tried opting out and I can't get out. Well, his opt-out window comes 30 to 45 days prior to the year anniversary. And so, it wasn't exactly a month ago. It was a few weeks ago that he had opted out. But the point is he was trying to sit there and figure that out and didn't understand the math that it's 30 to 45 days prior. You can't opt out when you're within 30 days of your anniversary. And again, it's just kind of bizarre. And each union has their own. Some of them copy each other. Some of them have their own unique dates. Some of them are 10-day windows. They vary. But again, he tried opting out. And so he's stuck in at this point for a year because he missed it by 1 day getting it in to opt out. And even doing that, he didn't understand what was going on. As most of the people I talked to, they don't realize that they had signed their rights away in the first place. I don't know how many, if any, of these people who are signing these membership cards understand the fine print, but unfortunately, that's the way that it is.
Well, I think it's extremely unfortunate that a lot of people, for better or for worse, trust their union to be at least somewhat honest with them when it comes to reading their contract, explaining their rights to them. So I think it's a little shocking for some of these members to see their unions really blatantly just kind of throw their trust away. I don't think most, I think there's a certain number of people that understand that their unions aren't entirely honest with them all the time, but I think the average person just assumes that they're there to help. So it's a little troubling for me to see a union just kind of, throw that trust out the window. So what I want to talk about now is how exactly do unions defend these arrangements? Because to an outsider, it looks like what they're doing is they're just trying to trap their members into years and years of paying without actually providing any kind of meaningful service. Lauren, have you seen or heard of any unions attempting to defend this practice in Ohio?
It is really interesting that you raise that point, Sam, because they are not able to adequately defend this decision. This practice is honestly indefensible, and they know it, and it really is designed, in my mind, and from where I sit and from what I've observed thus far, as a loophole to circumvent what Janus should otherwise be permitting these public employees the freedom to do, which is leave their union at any time they want. And, the Janus decision was considered not favorable to union bosses and people who benefit off of the maintenance and the protection of vast union membership across our state here in Ohio, and it is the case in other states as well. And this is their way to make a lot of money, to fund their different practices and political attachments and make the kind of investments in politics that they want to make. And if they are not confusing people and offering up this manipulative tactic in maintaining their roles, then they won't have the money they need to fulfill their obligations to politicians and to causes that they are trying to promote.
Matt, I want to push the same question over to you.
Yeah, it's absolutely a way to circumvent the Janus decision. The main argument that I've heard in support of the windows is basically trying to relitigate the Janus decision, right? They try to argue and that it isn't right that people have the right to opt out. That's literally their argument, is people shouldn't have the right to opt out. People should not have the right to not pay dues. So they do have that right, but that's their justification for trapping them, tricking them, lying to them, manipulating them, harassing them. Their justification is the ends justify the means. You shouldn't have this right, therefore we'll do anything we can to prevent you from exercising it. And that is literally what their argument is. They don't obviously phrase it that way, but that is their argument and their position.
Yeah, I would agree that that is sort of the argument that they make, that they don't, phrase exactly that way. Mostly in California, I think that their main argument is similar to what you're saying, Matt, which is just that they don't like the idea of freeloaders. They don't like that somebody could opt out and continue, getting their services, whatever those services might be. And regardless of whether or not their unit members actually want to get their services, they feel offended that it is possible to get them without paying the protection money. But I think this is a great topic. I do want to talk about it more at a later date, but I think right now we should take a little break and then come back in a few minutes with some more discussion. So Lauren, Matt, thank you for joining me, and we will be right back.
Wonderful. Thank you.
If you like what we do and you want to see more of it, please consider making a small financial contribution. The Freedom Foundation is a 501c3 nonprofit, and all donations are 100% tax deductible. Visit freedomfoundation.com/donate. All right, well, welcome back, everyone. Lauren, Matt, thank you both for sticking around. So what I want to get into now is, Matt, I understand that the Freedom Foundation recently had a big win in the state of Washington. Could you tell us a little bit about the Slidewaters lawsuit?
Yeah, so Slidewaters is a water park in Eastern Washington by Lake Chelan, and it is a 7-acre park that was told that there is no way they can safely open. And the owners attempted to negotiate with the state and said, can we come together? Can we at least start somewhere? They pointed out, what about 1 person per acre? How can you say that it's impossible for us to safely open? Certainly there's some way we can open. They make all of their money between Memorial Day and Labor Day, and they were forced to be closed nearly the entire time. They did open up for a brief amount of time and then were threatened with a fine and fined and threatened with potential jail time as well. So we are representing Slidewaters, and we recently did have a victory. Unfortunately, it came a little too late to save their 2020 season, but we did win and got rid of the potential fines and the loss of their license that they were being threatened with. There also will be a conversation next year. They are guaranteed a seat at the table, essentially, that if the pandemic's still going and businesses are still being restricted, that the state will sit down with them and discuss and negotiate a way for them to safely open. So that is a win, to at least have the possibility of opening, like the bowling alleys got, and many other businesses and different groups that had lobbyists negotiating on their behalf. So there is hope, but no guarantees, and we still have more pending litigation, but at least we did have a victory for Slidewaters in that area.
So Matt, you mentioned that they will have a guaranteed seat at the table next year if, for example, the pandemic is still happening. Are they going to be able to reopen next year since they had such a poor summer season?
Yeah, my understanding is they are planning to open next year. I know it's been rough on them. There was a lot of community support. I know that someone created a GoFundMe and raised, I believe, around $35,000 in just a couple of days to help them. And there's a lot of support, and they're doing everything they can. I think that they are planning on opening up next season.
Well, that's awesome. It's really good to hear that the community is really coming together for this group. I know that Slidewaters is an important part of Lake Chelan. So Lauren, I wanted to ask you a question as well. We talk a lot about, the lockdowns on the West Coast, but I'm interested to know a little bit about how things are going in Ohio.
Well, it has been, to say the least, very interesting. We have been on a curfew, or what I compare to be house arrest, for 2 weeks now. Starting at 10 p.m., we are required to be home. We're not allowed to leave our homes again until 5 in the morning. This was decided in the spirit of minimizing contact with other people. And this was a measure taken so that we would not have to shut down restaurants again. So this is, in the short term, what we are living with in Ohio to quote unquote curb the effects of the pandemic. I do have to mention that since the lockdowns, the curfew have been put in place 2 weeks ago, our cases have been increasing steadily. So it brings into question the effectiveness of it. So it will make me wonder what measures, creative measures, our government will pursue next.
Well, in California, we see a lot of, well, the same in Ohio, actually. We also are under a curfew from 10 p.m. to 5 a.m. But, you know, and well, that's unfortunate and everything. I think what's really interesting about this is we saw recently in California with Gavin Newsom deciding to go out to dinner with some healthcare lobbyists and, you know, do something that the rest of us couldn't really do or shouldn't have done, according to him. Have we seen anything like that in Ohio of any elected officials or governors kind of openly flaunting the rules to go do their own thing?
You know, no, perhaps we just don't have the amount of fancy restaurants or the capabilities for our politicians to kind of stuff their own rules, if you will. But I haven't seen a large amount of hypocrisy, although the problem we have encountered in Ohio is that there are certain businesses that are being treated in a harsher manner than others. And it seems like there has been some preferential treatment for some businesses, and then other types of industry or businesses are held to a stricter standard. And that can be very confusing and really a breach in public trust, because it doesn't make sense why you would really restrict or limit the abilities of one business to operate but not another.
Yeah, I would agree. It doesn't make a whole lot of sense, and I think you would have a really hard time convincing those store owners that feeding their families and taking care of you know, themselves would be considered non-essential when, you know, a liquor store or something would be allowed to stay open. Well, I think that is about all the time that we have for today. But Lauren, Matt, I want to thank you guys again for coming on the podcast. And for those listening at home, keep on checking back, and we should have another episode up in a little while. Thanks, everyone.
Thank you.
Thanks, Sam.